Mr. Trush, what case are you appearing on today?
The arraignment for Miss Trosper.
Trosper, okay. Mr. McFalda, I know that Jennifer contacted the jail. I don't see them connected. Can you give them a buzz really quick?
Sure. I will right now.
Thank you.
Hello?
Hey, I refreshed the schedule viewer, but I'm still not seeing the Seagull case.
Oh, geez, that would be because I didn't put it in.
Okay.
I'll do it right now. I'm sorry.
No, you're good. We still have to do this other arraignment, so.
I'll get it done.
Okay.
2 minutes.
Thank you.
Thank you.
Bye.
Bye.
They had someone in the box there, but they needed your number still. They're gonna put her on a tablet, so it looks like they're coming in.
Okay, great. Thank you.
Put you on the tablet. We have something in on the Polycom. So you guys have a seat.
All right, ma'am, are you Sarah Trosper?
Yes, I am.
Okay, all right. Can you hear me okay?
Yes, I can.
All right, we'll go on the record in People versus Trosper. This is Crawford case number 245294. The record should reflect that Ms. Trosper is present today by video from Crawford County Jail. We have Mr. Trush here present as appointed counsel for purposes of arraignment. And then we also have Mr. McFalda, the probation agent. Everyone's appearing by Zoom today for the record. Ms. Trosper, you're before the court on 2 alleged probation violations today. Do you understand why you're before the court?
Yes.
Mr. Trush, did you have an opportunity to speak with Ms. Trosper?
I did. I spoke to her yesterday when she was arraigned on the underlying charges that form the basis for the violations. Additionally, I spoke to her over the lunch hour today. We'd be prepared to waive a formal reading of those allegations and stand mute to the charges. She has been approved for counsel, and Mr. Thompson will be appointed on this matter as he was in the matters yesterday, and we would like to address bond.
Okay, so the court will enter a not guilty plea on behalf of Ms. Trosper with regard to both the alleged violations in this case. And Mr. McFalda, in terms of bond, do you have any recommendations?
Judge, just that I know she posted her bond already on the underlying cases. I think it was $1,000 on each file. There is some potential violation behavior that I haven't charged yet, as she picked up 2 R&O charges at her arrest. I have to get more information before I go forward or decide to go forward with any further violations. But Judge, at this time, I just defer to the court, Judge. I just think a low cash bond would be appropriate.
All right, given the nature of Ms. Trosper's underlying charges in this case and the fact that she's already posted bond in the underlying cases, the court finds that that's sufficient. Has she had any trouble, Mr. McFalda, have you had any trouble keeping contact with Ms. Trosper at all?
No, Judge.
Okay, so I'm not concerned about Ms. Trosper's appearance at future hearings. And I think a PR bond is sufficient then to ensure that. So the court will set a personal recognizance bond on the violations of $1,000. The court will include all standard conditions of bond and all conditions of probation as the conditions of that bond. And then the court will set this for hearing. Mr. Trush or Mr. McFalda, I mean, did we want to set this out a little bit, given that the violations are based on underlying charge conduct?
I would think so, Judge.
And I
Okay.
would indicate, I don't think that would be prejudicial in any way because again, she has posted the bond, so I don't expect she's going to remain in the jail. And given those circumstances, it does generally make sense for the underlying charges to work their way through before we address the violation.
Okay, and it looks like at least one of the underlying charges at least, and it sounds like perhaps more if there's RNOs that are going to be added, will be felony charges. So I'm going to set this 60 days out to give the case an opportunity to be found over to circuit court if it gets that far, and then we'll have a better idea. So the court's going to set this for hearing in 60 days. So Ms. Trosper, between now and then, again, it's a PR bond, so you don't have to post any money to be released on the probation violation, but you're going to continue to be subject to all terms and conditions of your probation, and you need to make sure that you stay in touch with Mr. McFalda. Otherwise, we may, things may change and you may have to be remanded to jail. So does she need to touch base with you today, Mr. McFalda, or have you already made those arrangements?
I've already talked to her this morning and we're all set.
Okay. Ms. Trosper, do you have any questions at all?
No, sir.
Okay. All right. Thank you. That's all for this hearing today, and all parties on this case are free to disconnect at this time. All right, sir, is your name Gregory Tobias?
Yes, Your Honor. I'm sorry, I don't have my glasses on, so I can't see very well.
All right, are you able to hear me okay?
Yes, I hear you just fine.
Okay, if at any point you're unable to hear what I'm saying, just let me know and I can repeat that for you, okay?
Okay, thank you.
All right, so we're gonna go on the record, two different files, District Court file number 2644292-FY-3 and 26-44277-SM-3. The court is conducting this hearing today on behalf of Judge Hesselink, and both files are set for hearing. We have a new file that's set for arraignment and a separate file that is set for a request for bond modification. The record should reflect that Mr. Tobias is appearing today by Zoom from the Otsego County Jail. If I could have counsel put your appearances on, please.
Good afternoon, Your Honor. Aaron Fortier on behalf of the people.
Larry Brown on behalf of Mr. Tobias.
And Mr. Brown, have you been appointed in the other file, or are you just appearing for purposes of arraignment on the felony file today?
I am appearing just for purposes of arraignment. He did not qualify for appointed counsel.
Okay. All right. So Mr. Tobias, and I'm referring to the new file here today. You're before the court for arraignment on 3 different charges. At count 1, it's alleged that you committed the crime of fleeing or eluding 3rd degree. That's a felony that carries with it a maximum possible penalty of up to 5 years and or a $5,000 fine. Do you understand that?
Yes, Your Honor.
Count 2, the allegation is malicious destruction of police property, and that is a felony that carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine. Do you understand that?
Yeah, 9 and 10.
And then count 3, resisting or obstructing a police officer. That is a felony that carries with it a maximum penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Could you read that one more time? What was this last one?
Sure. Count 3 is resisting or obstructing a police officer. And that's a 2 years or $2,000 fine as a maximum possible penalty. Do you understand that?
Yeah, I do, yeah.
All right, I'm going to
Sorry,
go through
yes,
a few. That's all right. I'm going to go through a few things with you with regard to your rights. You do have the right to have a trial as to each of these charges. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand that you have all of those rights?
Yes, Your Honor.
You also have the right to have an attorney present at any subsequent proceedings. Mr. Brown is here for purposes of this arraignment. If you could not afford an attorney, one would be appointed for you at public expense, or you could hire your own attorney. If at any point during this hearing today you have questions or want to talk to Mr. Brown, then I would allow a breakout room and give you an opportunity to speak privately with him. I want to understand all of that.
Yes, Your Honor. I do have one question though, just
Sure.
for you, like for everyone. I'm pretty sure I got read 5 charges last night. Is there 2 more charges coming yet from somebody else or something, or a different thing, or is it just like 3 from yesterday? I just want to know how much more is coming down the line at me, you know? Like I made a really big mistake. I thought somebody was trying to.
Mr.
I'm
Tobias.
sorry, I'm not supposed to talk. Sorry.
Yeah, I don't want you to say anything about the underlying
About the
matters.
case, yeah, I just didn't know if there's 2 more. I'm pretty sure I was read 5 crimes like at midnight or something last night that I committed, or whatever, you know what I'm saying? Like I'm being accused of.
Mr. Tobias, I would advise you just not to talk at the moment.
I'm sorry. Yes, Your Honor. Or I mean, thank you, Larry.
So, Mr. Tobias, I have in front of me a 3-count summons. So as far as I know, those are the only criminal charges. There may be some kind of traffic citations or things that aren't criminal charges.
Oh, okay.
But I don't,
Maybe it was
that's not something. Yeah, that's not something that I would be arraigning you on, and I don't have that information. So all I can tell you is in terms of crimes, you're only being charged with the 3 crimes that I've listed today.
Thank you, Your Honor. The others must have been, like you said, civil infractions.
Okay.
Right.
Right.
I just wanted to make sure I was caught up.
Sure. In terms of an attorney, I know it sounds like you already were screened for appointed counsel. Did you wish to request an additional screening in light of these new charges?
Screening for attorneys?
Right,
sorry,
to see if you qualify.
No, I'll just hire one when I get out of here, whenever that may be, or through the phone or whatever. My family had hired a couple or talked to like 4 attorneys already for this. So I've got a couple family attorneys that are coming. I just don't know. I didn't have much access for phones, so I just don't know what's going on, and my head's killing me. Sorry.
Okay. Did you know how you wanted to plead to the charges today? Did you want to talk to
not
Mr.
guilty.
Brown? Okay.
Just not guilty for now until I can do something else. I think that's what I'm supposed to do.
All right. So the court is going to enter a not guilty plea on your behalf with regard to each of the charges in this case. The next hearing that we're going to have in your case, Mr. Tobias, is going to be on January 21st at 10 a.m. That's a felony pretrial. You'll be provided with a written notice of that date. It's also going to be set for an additional hearing on January 22nd, and then a preliminary exam on January 29th. But again, your next appearance in court will be January 21st at 10 a.m. And like I said, you'll receive written notification of that date and time. And if you have an attorney that files an appearance on your behalf, they'll be provided with that information as well.
Okay, thank you very much.
In terms of bond pending that hearing, Mr. Fortier, on behalf of the people, anything with regard to the bond in this case?
Your Honor, I did submit a bond recommendation sheet where I think based on a couple of factors, mainly that Mr. Tobias is exhibiting escalating conduct continuously. So really this kind of ties into the first case. He's on bond right now in case 26-44277-SM, which is a disorderly conduct obscene case. and that one stems from an incident that occurred downtown at the county building and the sheriff's office, resulted in some action there. And now he's alleged to have been fleeing from a traffic stop, ramming into a police vehicle, fleeing on foot, and essentially barricading himself inside of a house before he comes out. I think he's presenting himself as somewhat of a danger to society. If he's willing to do that to the police, who knows what he's willing to do to the normal citizens. So I think based on that, I am requesting a higher than normal bond of 50,000 cash or surety. In addition to that, their standard conditions of bond, I would ask that there not be any drugs or alcohol consumed, that he report via community corrections. He's already got a couple of PPOs against him, but just reiterating no possession of any firearms, no purchase of firearms. And then I think it would be appropriate if CMH were to be contacted and maybe do an evaluation prior to any release.
Thank you, Mr. Brown.
Your Honor, I was there for Mr. Tobias's arraignment last week on the misdemeanor charge. He's 46 years old. He is a lifelong resident here, fourth generation. He does have a wife and kids. There was no alcohol or drugs, to the best of my knowledge, involved in any of this. I'm not going to go into great detail about my conversation with him, but there are clearly some mental health issues that he is struggling with right now, and he does acknowledge that. He does have a therapist that he is currently seeing. He advised me he has taken medications. They're giving him something in the jail, but I want to ensure, especially with seeing a therapist and having regular prescriptions, that he's getting what he needs. And I think that is one of the biggest issues here. I don't hear anything about a criminal history, given his age and his relative lack of criminal history. I would ask the court to focus on something as far as mental health goes. I'm not opposed to a CMH evaluation. Hopefully they can get him some help here.
Could I speak, Your Honor?
Yep. Again, you may want to just make sure that you follow your Mr. Brown's advice and not say anything about the facts of what happened, because anything that you say here could be used against you later. So, but yes, absolutely, you can, whatever you'd like to say.
I would like to go see my therapist, and they don't have my right meds here. Like, it's an old script. They doubled up the one, which they can just give me 2 of that pill, my wife said, or maybe 3. I don't remember. But my dog also caught on fire, and I just really, we had 2 dogs that were in the truck with me when this all went down, and I just really want to go make sure my dog's okay, like really bad. Like, I will be good. I've never been violent. I don't believe in violence. I don't believe in, I make people want to punch me, but I don't want to hurt anyone. My uncle was murdered, and I made some mistakes. I thought people were trying to hurt me.
Mr. Tobias, again, I'm going to caution you about going into anything that might have happened or not.
I just want to go see my dog. My dog, I'm sorry.
Okay. All right. Mr. Tobias, there's a number of things that the court has to take into consideration when it's making a decision about the type of bond and the amount of bond. There are some things that I think are working in your favor in this case: your lack of a significant prior criminal history. You have significant ties to the community. The court doesn't have any concerns necessarily that you wouldn't appear for future hearings based on your ties to the community. There are some things working against you. The fact that you were on bond for a disorderly offense at the time that these offenses occurred, and that happened relatively recently, gives the court cause for concern regarding public safety. The fact that this did involve fleeing and eluding, and at least allegations of some evasive and potentially assaultive conduct in terms of ramming a police vehicle or causing damage to the police vehicle. Those are things that give the court concern for public safety. I do believe, based on the statements here on the record and just my observations of you here during the course of this hearing, I do have some concerns about any ongoing mental health issues, which again, I think relates to public safety. So for all of those reasons, I do find that a high bond is necessary again primarily for the purpose of public safety. So the court is going to set bond in the amount of $50,000 cash or surety. The court is going to set all standard terms and conditions of bond. In addition, no use of any drugs or alcohol. The court is going to order that CMH conduct an evaluation prior to any release. The court is going to refer this to community corrections to accomplish that. And then we'll proceed on as I stated, on the 21st. I think Mr. Tobias, in terms of the other file, there was a request to leave the state for work. I think in light of this additional new conduct here, the court is not going to modify the bond, and one of the conditions of bond would be that you remain within the state of Michigan. And all of that will be stuck up in the paperwork that you're going to receive. Mr. Fortier, anything further that we need to address for the record here today?
No, Your Honor. Thank you.
Mr. Brown.
No, Your Honor, thank you.
Mr. Tobias, did you have any questions at all?
I guess, so does that mean I can get out of jail? I just gotta pay money still, or do I have to stay here until the 21st?
No, if you can post that bond amount and comply with all the conditions of bond, then yes, you can be released pending that hearing.
Will that be today? Like if
I don't know, that's
can I come today? Or do I
I'm
have
gonna
another
say,
hearing? I'm sorry, I'm confused.
That's all right. I'm going to sign that bond paperwork immediately here after this hearing. So as soon as you can post that amount, you can get released.
Oh, okay. Thank you, sir.
All right. Okay. Thank you. That's all for this hearing today.